On July 4th, Nolan Wells went to Horn Island with friends. Then the timeline breaks. By July 6th, he was dead, and the public still cannot see the evidence that resolves how he got from one point to the other. The boat's GPS gives a precise departure time. The phone gives a trail of questions. Two witnesses are said to place Nolan on the island after his friends left. And now an unauthenticated handwritten account claims an entirely different sequence, including murder and a secret return of his body to the island. None of those claims can be treated as proven. So the question I'm following is narrower and harder. When rumor is stripped away, what can the documented timeline actually establish about Nolan's final hours? That distinction matters because this case has been argued in reverse. People began with conclusions, then searched for details that fit them. But the record is incomplete. One camp sees an accidental drowning. Another sees a killing and a cover-up. But the public record, as described through mid-August 2026, is still incomplete. The state autopsy and toxicology findings have been finalized but sealed. The independent examination commissioned by Nolan's family left both the cause and the manner unresolved. Saying more investigation was needed, the planned joint forensic review of the phone still had not taken place, and a grand jury presentation had no publicly announced date. I'm going to keep those categories separate: what is established, what a witness or attorney has claimed, what is contradicted, and what remains unknown. Because the most dramatic version of this story is not automatically the most accurate one. The information vacuum is part of the story itself. A handwritten account began circulating online with extraordinary allegations. It claimed Nolan drank very little on July 4th. That tension with one friend escalated after an exchange involving Nolan's phone. That Nolan was later killed, hidden off the island, and then transported back to Horn Island before his body was found. It even supplied a motive, claiming Nolan intended to cut ties with the group. That document has not been independently authenticated. No verified author has been identified. No official finding has established its account of a killing, a hidden body, a return trip, or the guilt of any named person. The document may contain true details, false details, or a mixture. Nobody can responsibly skip that problem. And yet it gained traction because it seemed to answer questions that official releases had left open. The note about alcohol collided with an early Mississippi Department of Marine Resources notation describing Nolan's alcohol intake as heavy. But that early notation reflected witness information, not a publicly released toxicology result. The online account claimed Nolan had consumed perhaps half a seltzer or one seltzer and was thinking about his upcoming football season. That could matter if authenticated. Not yet. So the correct conclusion is not that Nolan was sober and not that he was heavily intoxicated. The correct conclusion is that public claims about his consumption were contested while the official toxicology findings remained unavailable to the public. The same discipline applies to allegations about controlled substances. That is still unproven. The handwritten account accused a friend of using a controlled substance and described tension after Nolan used his phone. Brandon Tatum also said he had been told by a person he considered reliable that controlled substances were present and that someone close to Nolan expected substances to appear in toxicology. Those were allegations, not laboratory findings. The sealed toxicology may eventually support, refute, or complicate them. Until then, using them as proof of a motive or homicide would be speculation dressed as certainty. That distinction is not a technicality. It is the difference between investigating a person and publicly convicting one without verified evidence. Attorney Tyler Cox, representing members of the group that traveled on the Triton, said two witnesses who knew Nolan saw him alive on Horn Island around 6 p.m., well after the Triton left. Counsel associated with the group described the witnesses as credible and said the identifications were positive. Their names and the full circumstances of those observations had not been publicly released. Nancy Grace and guest attorneys challenged the strength of the claim, pointing to ordinary eyewitness questions: distance, lighting, impairment, obstructions, timing, and exactly what the observers saw. A video discussed publicly showed a person from behind in blue shorts, but that image alone could not settle identity. That creates a clean evidentiary fork. The conflict is direct. If reliable witnesses truly placed Nolan on Horn Island around 5:50 or 6 p.m., the Triton's GPS matters enormously. The boat's track reportedly shows departure at 4:31 p.m., movement near Fort Bayou around 5:52, and docking a little after 6. The people on that boat could not be in two places at once. But if the sightings are mistaken, their exculpatory value collapses. There is also a separate claim, cited by the family's attorney, that another witness said Nolan boarded the return vessel. That claim directly conflicts with the version that Nolan remained behind. Put your answer in the comments. Which evidence would change your view most? Verified post-departure identification or verified proof that Nolan was on the return boat? That is the kind of disagreement the case can actually resolve. The national attention around Nolan's death magnified every gap, and the audience exploded. Nancy Grace dissected the timeline. Brandon Tatum discussed tips and allegations. CNN and the Clarion Ledger reported on the phone handover. The Sun-Herald documented threats. TMZ was cited in connection with a claimed post-departure sighting. United Cajun Navy material was invoked in discussions about video and the island timeline. Ben Crump became a public voice for Nolan's family. High-profile figures contributed to a reward that reached a reported $125,000. The result was enormous pressure for answers, but pressure also produced noise. One example came when fraudulent toxicology reports began circulating. That changes the standard. Sean Tyndall, Mississippi's public safety commissioner, publicly called at least one of those reports counterfeit. Attorneys representing the young men also described multiple fake reports. The existence of believable forgeries matters because an unauthenticated document can look persuasive before anyone tests where it came from. The bigger the audience became, the more incentive there was for attention seekers, hoaxers, and people chasing reward money to insert themselves into the case. That does not make every leak false. It does mean each one has to earn credibility through authentication. The consequences were not confined to comment sections. Families on both sides described threats and harassment. At least 3 people were reported to have faced criminal charges connected to threats surrounding the case. Judge Ashley Cole's family provided recordings of threats, and federal charges were brought in cases involving alleged threats to kill her or bomb her residence. Relatives of Nolan's companions retained attorneys and discussed possible defamation claims. Meanwhile, Nolan's parents said they were receiving little direct information and often learned developments through news coverage and social media. One family was demanding answers about a dead son. Other families were defending young men who had not been charged with killing him. The public debate frequently treated those positions as if only one could deserve basic fairness. That was a mistake. Before the case became a national argument, Nolan was a young athlete preparing for his second football season at Southwest. He was preparing. His family described a player who had been training with his father and thinking seriously about the next stage of his life. They said football was not an abstract dream sitting somewhere in the future. It was already shaping his choices, his schedule, and the way he approached the coming year. That detail became important because competing stories about July 4 often turned on his behavior, especially how much he drank and whether he would voluntarily stay behind on Horn Island. His family's description was consistent on one central point. They did not recognize the idea that Nolan would casually separate from the people he came with to remain on an island with a woman he barely knew. She rejected it. His mother put it plainly, "My son would never do that." She also framed the rule simply, the group that leaves together should return together. That belief is not physical evidence. Character evidence cannot by itself prove where Nolan was at 4:31, 5 or 6 p.m., but it explains why the first account the family heard did not sit right with them. Their suspicion did not begin with the anonymous handwritten allegations. It began with a version of Nolan's choices that they believed did not match the son they knew. The same family accounts portray Nolan as someone who moved among several groups of friends and often tried to settle conflict rather than prolong it. The circulating handwritten account uses that image to support a motive theory involving a friendship rupture, but that theory is unverified. That distinction matters. The useful part is the distinction. Nolan had relationships broader than one boat trip, one party, or one circle. The people close to him could compare what they were being told with years of ordinary behavior. That gave them reasons to ask questions. It did not give them the power to turn those questions into facts. I think this is where true crime coverage often fails a victim. Biography gets reduced to a tool for arguing the case. That is the trap. The athlete becomes evidence that he would never drink. The peaceful friend becomes evidence that someone else must have started a fight. The responsible son becomes evidence that he could not have made a risky choice. Real people are more complicated than the roles assigned to them after death. Nolan's football plans matter because they show where his life was pointed. His family's memories matter because they show what was lost. But neither should be weaponized to manufacture certainty about a disputed hour on Horn Island. What is certain is that July 4th was supposed to end with Nolan coming home. It did not. His phone, his keys, the boat movements, and the later search became evidence because he was suddenly missing. Those objects are mundane until the person they belong to is gone. Then every handoff matters. Every minute matters. Then in this case, the phone became one of the most contested objects of all. Nolan's parents were not passive observers once those gaps appeared. They retained attorney Ben Crump. They commissioned an independent autopsy. They brought in digital forensics specialists and other experts. They pursued preservation of social media data through legal process. They asked for federal involvement, and they repeatedly said they would accept an accidental drowning conclusion if it could be demonstrated through a thorough, verifiable investigation. The phrase Crump used was simple: trust, but verify. That position also explains the fight over the phone. On July 15th, the family's legal team met with the district attorney's office and discussed a joint forensic examination. The proposed arrangement would place the family's specialist, prosecutor's personnel, and potentially the FBI together for a single extraction, with chain of custody and access controlled by an agreed protocol. Later, while Nolan's parents were outside Mississippi, the district attorney's office sent a demand for the phone on a short deadline. The family said it could not meet that deadline while traveling, and reaffirmed that it was ready for the joint examination once the technical terms were finalized. Critics called that withholding. The family called it evidence protection. There is emotional weight behind the dispute because the family described the phone as one of the few physical belongings they still had from Nolan. That is personal. But emotion cannot decide forensic procedure either. The clean solution is the one both sides had already been discussing: an examination with clear custody, defined access, and a record of what was extracted and by whom. As of the period covered here, that examination had not happened. That means one of the most obvious potential stores of location data, messages, photographs, app activity, and deleted information remains central to the argument instead of becoming a completed forensic answer. The family also faced a second burden. Both sides were hurting. They were grieving while being accused online of prolonging the case for money, attention, or fundraising. At the same time, the families of Nolan's companions were receiving threats from people who had already decided those young men were killers. No evidence justifies threats against either side. No sealed report makes harassment investigative work. If you want me to keep following this case as evidence is actually released, subscribe for the verified developments, not the rumor cycle. Now go back to July 4th. The gap is basic. The group reportedly left a residence around 10:30 a.m. and traveled by boat to Horn Island, arriving around late morning. They spent hours in a holiday party environment. The Triton's GPS later became one of the strongest fixed points in the timeline, placing its departure from Horn Island at 4:31 p.m. The dispute is who was on it. Members of the group said Nolan remained behind. That claim is disputed. Post-departure witnesses, through attorneys, were said to have seen him around 6 p.m. The family rejected the idea that he voluntarily stayed with an unfamiliar woman, and Crump cited a separate witness claim that Nolan had boarded the return boat. Outbound video exists, including footage discussed as possibly showing Nolan wearing a white shirt with light blue shorts. But no corresponding public return footage has surfaced for the three boats said to have traveled together. That absence does not prove Nolan was on the Triton. It removes one way the public could independently check who was. Then the phone reappears in the timeline. That delay matters. Tashima Hans, Nolan's aunt, said the family used Life 360 and Snapchat to locate the phone, then sent her to the house. She described arriving to a darkened living room where young men were watching television. She said she dealt directly with Wyatt, not Warren, and waited at least 15 minutes while explanations shifted about where the phone was and who would retrieve it. A young woman eventually brought the device in from a truck. Hans described tension during the delay. The group's public account characterized the handover as straightforward. Those versions conflict on a point that should be simple: how long it took, who controlled the information, and whether there was friction. The keys were a separate episode. They were said to have been left at the house from the previous night and were located after a message indicated they were on an Xbox. That distinction matters because online retellings can merge separate events until they sound like one confrontation. They were not the same handoff, and Warren's own later descriptions created another issue. He reportedly gave details about the phone exchange, even though both Hans's account and other interviews placed him away from the house at that moment. That does not prove deception. It does create a source of knowledge question investigators can test. There is also dispatch audio indicating officers were en route to a residence associated with Chancery Court Judge Ashley Cole during the early missing person response. Why remains unclear. Cole is identified as Warren Hudson's stepmother. No public incident report, body camera recording, or official explanations cited in the case account clarified exactly why officers went there, whom they intended to speak with, or what occurred during the visit. The timing made the trip a focus of suspicion, but suspicion is not proof of improper influence. A separate controversy involved two similar phone numbers: the Jackson County Sheriff's Office after-hours tip line and Judge Cole's office line differed by only 2 digits. The Clarion Ledger reported that the resemblance caused misdials, but said calls to the official tip line were not being routed into the judge's chambers. That clarification matters because the more explosive claim that tips were intentionally routed to a judge connected to one of Nolan's companions was not established. Misdials are real, and intentional diversion was not shown. The investigation itself then became a contradiction people could see. The posture looked unsettled. The sheriff's office had publicly indicated there was no sign of foul play, while questions continued about the autopsy, the phone, eyewitness accounts, boat movements, and a possible grand jury presentation. Guest attorneys debating the case noted that a grand jury can examine evidence even when the public does not know whether prosecutors believe a crime occurred. The district attorney has said disclosure is limited to protect the investigation and grand jury process. The office maintained that the case was being handled under normal procedures and that evidence was still being collected and verified. One unresolved issue is the use of search dogs. Timing matters. Experts appearing in coverage explained that human remains detection dogs can become useful very early because decomposition odor develops quickly, but their value falls as a scene becomes contaminated, weather changes, people move through the area, and water or tides affect scent. The public record described uncertainty about whether cadaver dogs were deployed early enough or at all. Grace herself acknowledged a crucial limitation. They may have been used and the public may simply not have been told. That is exactly the kind of unknown that should stay unknown until records settle it. The highest risk claim remains the circulating handwritten account because it offers the most complete story. It alleges a confrontation, death, concealment away from Horn Island, and a later return of Nolan's body. It names people in connection with tension and fear. It supplies a motive. It explains why early searches supposedly failed, and because it closes so many loops at once, it feels satisfying. That is precisely why authentication matters most here. A story that explains everything can be true. It can also be constructed from facts already circulating in public. The document's timing raises that problem. It appears to reflect details and controversies that were already being discussed after Nolan's disappearance. A substantial reward was available. Fake toxicology reports had already demonstrated that convincing false material could circulate quickly. No independent authentication identified the writer or proved first-hand knowledge. So I will not treat the account's murder narrative as fact, and I will not identify any friend as Nolan's killer. The state's sealed findings, the digital evidence, witness testing, and any grand jury action carry more weight than an anonymous page. The strongest public evidence conflict is therefore not a secret confession. It is the collision of timelines. The Triton leaves at 4:31. 2 witnesses are said to see Nolan later. The family cites another witness who allegedly places him on the return boat. No public inbound video settles the passenger question. His phone ends up back on the mainland and is handed to a relative after a disputed delay. His body is recovered 2 days later. The official autopsy and toxicology are sealed. The independent autopsy says undetermined. That sequence leaves room for accident, for an event after the group departed, and for other possibilities investigators may be examining. It does not publicly establish murder. And that brings me back to the question from the beginning. Those are fixed points. What can the documented timeline actually establish about Nolan's final hours? It can establish fixed points, not a complete narrative. It can tell us when the Triton moved. It can identify competing witness claims. It can show that Nolan's phone returned to the mainland and that accounts of its handover differ. It can show that officers went early to a residence associated with one companion's family. It can show that important forensic results exist but remain sealed. It can show that an independent autopsy did not resolve cause or manner. It can also show how quickly unsupported certainty rushed into every gap. That is not an empty conclusion. Those are testable questions. It tells us exactly what evidence would matter next. A verified forensic extraction of the phone could test location and communication claims. Full witness statements could show whether the alleged 6 p.m. identifications survive scrutiny. Return trip video, if it exists, could answer a basic passenger question. The sealed autopsy and toxicology could confirm or destroy entire branches of speculation. The reason for the early visit to Judge Cole's residence could be documented rather than imagined. And authentication or disproof of the handwritten account could determine whether it is evidence or another dangerous distraction. Until those pieces are public, the most responsible position is also the most demanding. Both standards matter. Nolan Wells deserves more than a premature label of accident if the investigation cannot support it. He also deserves more than a premature declaration of murder aimed at uncharged people. The families of his companions deserve protection from threats, and Nolan's family deserves answers that can withstand scrutiny. A case this contested will not be solved by choosing the loudest story. It will be solved, if it can be solved, by evidence that survives cross-checking. August 19th is identified by the family as Nolan's birthday, and they have called for continued attention and prayer. That date sharpens what can get lost in the argument. He was preparing for another football season. That was the future. He expected to come back from July 4th. The people who loved him are still waiting for a version of events that is not just plausible but provable. If this case matters to you, share the verified facts, not the accusations. Because the final answer should not belong to the rumor that arrived first. It should belong to the evidence that holds up last.